Good evening, everyone. Welcome to today's seminar titled The EU as a Global Digital Actor, Institutionalizing Global Data Protection, Trade, and Cybersecurity within the framework of the Jean Monnet module Enacting. My name is Silvia Talavera Lodos, and I am a PhD candidate at the Scuola. Before we begin, I would like to introduce the author of the book, Professor Elaine Fahey. She's Professor of Law and Deputy Head of Department at the City Law School at City University of London. She was awarded an Erasmus Plus Jean Monnet Chair in Law and Transatlantic Relations from 2019 to 2022. And she's an expert in EU law and global governance with a focus on transatlantic relations, trade, and the EU area of freedom, security, and justice. We are very happy to have you here. Now let me introduce you to our first discussant, Dr. Filippo Fontanelli. He's Senior Lecturer in International Economic Law at the Edinburgh Law School. He's very familiar with the city of Pisa, as he holds a degree from both the University of Pisa and the Scuola Superiore Sant'Anna, where he also obtained his PhD. His area of expertise lies in international economic law, human rights, and public international law. Thank you very much for here. And our second discussant, Mr. Kunhao YANG, is pursuing his PhD at the European University Institute, where he also obtained an LLM in European law. He's also the coordinator of EU-wise International Economic Law and Policy Working Group. Thank you very much for being here. Regarding our schedule for this session, Professor Fahey will deliver a 25-minute presentation, followed by 15-minute discussions from our speakers. And following their interventions, we will have a Q&A session. Without further delay, I now invite Professor Fahey to take the floor. Thank you. Thank you so much.
Thank you so much. I'm incredibly blind, it turns out, as I get older. I could barely see the screen there. So this book in particular aged me. It was my COVID lockdown project. So it's so lovely to be here. That I've only been to Pisa maybe once 2 years ago, and then about a very long 15 years ago. So it's such a lovely community you have here. So it's very nice to see you all. Incredible things. It seems like a very special place. Can you hear me okay? Oh, sorry, I'll like them. Yeah, so this book, I apologize sincerely that the book is the wrong color on this, because the publisher and I clearly had some miscommunications. It's actually a red book, which is terrible for an Irish person to have a red book, but it is actually, it was originally green. I don't know what dreadful things Heart did to me. No, I really enjoyed writing this book, and as I said, I wanted to write this for a long time. So I've submitted the text of this manuscript on the 31st of January 2022, which seems like a very long time ago. And I don't know, it had a feeling of being a slightly second PhD feel to it, but I don't know if that, I was locked in my home in London writing this. But just about 2 months after I finished this book project, a huge number of things happened, and I thought I'd talk about them today. So in some senses, some of the things are quite, it surprised me how outdated it was. Or the last time I was in Italy, and Kunhao and I met in Bologna, especially the China case study was something that I really wanted to talk about. So I'll talk about a selection of things, and I hope that I'm not speaking too quickly if English is not your first native language. I do have a tendency to rabbit on. But I really enjoyed writing this, but as I said, it feels like a very strange project to present to you now, but I'll try to go through it with you. So I suppose the first thing to say to you is that I started off writing. Well, I did a big chunk of work at the start of COVID at the UI. I was a visitor on sabbatical in 2020, and I got thrown out of Italy in March 2020. I was left with all my books and everything were there, and I had to really reevaluate my project. But at the start of 2020, when I started to work on certain aspects of this book, the EU had just announced its new strategy for data, the single market of data, the common data spaces, all the DSA, DMA, all that kind of stuff was just coming out. And kind of as I was starting to submit the project, all of, digital sovereignty, localization, the challenges with the Schrems case, the issues about putting DSA, DMA, all the alphabet soup into regulation were becoming much more apparent that there's a huge volume, but hard to see this in its context. And I think many of you, even if this is not your background, you probably know, you get the sense of this. I think it's hard, no matter who you are nowadays, to see that the EU has done a huge amount, and yet it's very difficult to kind of synthesize those questions. And I suppose today, I don't think things are this is a very clumsy overview in my part, but things like strategic digital sovereignty, people will tell you, is much more important than digital sovereignty, where geopoliticization of everything is the topic that most political scientists think now is much more important than anything ever. There's a huge amount of soft law, that's really problematic. I'll talk about that actually tomorrow. And in general, the DSA, DMA, it's all been litigated. So in a short period of time, a lot has happened, and that kind of is it's a strange way to start off a book talk, to tell you that firstly it's out of date, and secondly that there's such massive shifts in the thinking as to what the EU does. I think it's fair to say that you have to be kind of brave to write about anything digital nowadays, despite the fact that there's so many people are compelled to write about the digitization of society. And in fact, if you're to synthesize this a bit more carefully, you might say bottom up, top down is a real collision. There's people who want to attack it. There's those forces externally are very much, shaping the internal, not necessarily new, but, even what is the internal and the external in this context is very difficult to pinpoint, and it's a moving landscape. It's very much trying to shoot at a moving target, and that's not unique, to that. European law has always been like that, right? It's very much an evolving subject, but I think it is fair to say that's a context of note. Okay, and this logo is typically the logo. I don't know if anyone has a migration background. People, talk about Europe, especially, if you're talking about the problem areas of regulation and governance, migration is a very visible issue. The EU has a lot of challenges with. So Fortress Europe, we often speak about the problematic borders of the EU, this exclusion and so on. But I suppose, it also symbolizes very well data issues and digital governance and digitization challenges, that the EU leads really high standards, but doesn't really put them into practice in international trade agreements. In digital trade has a big struggle pushing it to partners and say, you want to be like us, or what, this kind of new colonial or whatever colonial attitude, or is it too political, or is it too, I don't know, there's so many ways of shaping it, but this is the idea of what are high standards, right? If you have high standards, even within the EU itself, right? We've, a lot of Scandinavian countries with very high solidarity, quality of life, and then, lots of other parts of Europe that can't afford it. And that's a reality of large going to homogenous. What is homogenous? And I think there was really interesting studies done at the start of the introduction of the GDPR by NYU Stern Business School, a great one about, would American companies leave the EU? And I'm Irish, I grew up in Dublin, and I've seen the Irish GDP explode through tech companies. Loads of my friends who are in college with their all legal advisors in all the big tech companies, and it's a massive area of understanding contemporary Irish economics, but also the EU's role in all of this. It hosts all the big stuff, and it doesn't get the revenue from it. All this critique of the EU for not being able to innovate enough. But there's a lot of interesting literature also coming out from NYU just last week. From I don't know if you know, Kevin Davis has a great project on how much the GDPR has engendered compliance in the US. Not necessarily Brussels effect, but just understanding good standards. So you need some regulation, and the EU has offered this. And I'm sure you all know this, whatever. And as someone who's living in the UK, I face very regularly, this discussions about what does Brexit mean for the GDPR and your silly cookies and your banners. I'm sure if any of you are working on, from outside the EU, you listen to this all the time as well. On, is it really important to understand that you as a global data actor, or was it just a first mover? Did it have first mover advantage, and that's it? And I'm sure many of you, or maybe some of you, have heard this about Meta's continuing threats, even being in its SEC filings. If the EU is going to continue to regulate, maybe we'll just leave Europe. Europe is very old, it's rich, but it's not the biggest entity in the world. There's lots of other regions of the world, many other in particular, looking south, looking at other parts of the world. So when I was writing this book, I mean, there were a slightly different set of debates. I know how good your eyesight is. If yours is as bad as mine, I apologize. I will try to assist you. But what I was trying to do was to describe the advancement of EU data flows in a whole variety of areas and digital trade through the framework of something called institutionalization. And I felt, and I still feel, that there's not enough discussion between data lawyers, cybersecurity, digital trade experts. They're very siloed fields. And what is data? What is digitalization? I still feel that I live in different worlds. I've done a lot of transatlantic stuff, particularly over the years, and it's not, it's a very difficult question. Who's defining data and whose data? And I was looking at large-scale regimes. I wanted to study big stuff, things that are across borders. My PhD is in EU and international relations, political science. So I felt that at the time of writing this, the EU-US, EU-Japan, EU-China were really interesting case studies as three of the largest regimes in the world that the EU engages with. The EU-US is one of the largest economic data transfer zones in the planet. The EU-Japan has the largest safe flow of data area, the first after the GDPR, and EU-China is a lot more difficult and esoteric, but I think is a very good case study, and China is frequently misunderstood in literature, in my opinion, but it gets obviously very difficult and political in different respects, but we can talk about that later. So when I put this together, I was looking at the EU as a data actor, a trade actor, and a cyber actor. And then I had three case studies, and I still feel that this, somehow I'm presenting something that isn't necessarily very well accepted, and I'm using the framework. I'll talk about institutionalization in a moment, but I'd be really curious to hear your thoughts on this. How do we understand data? Why is data siloed? Or if you're from a different background, I think some of you are constitutional, international, and so on, but how you frame this. And then the three case studies. So I think that the transatlantic case study continues to be really interesting and important, but at the time I wrote it, it was bad. It wasn't actually a good case study. It was surprisingly weak. That has changed. EU-Japan relations, I thought, was a very good example of East Asian convergence, and I'll talk about that in a moment. And EU-China relations, as I said, I still think is very much misunderstood about reversed convergence. I find the Chinese legal order to be very receptive and open to European ideals, but it's much more a question of institutional issues. And maybe we can talk about that later if you've an idea in all of this. So a lot to unpack there, and I'll try to whip through it, and maybe we can get to some questions, but please feel free to stop me if there's something that you find interesting or not. I know it's not everyone's cup of tea. Okay, so where do I begin? Well, for a long time I've been very interested in this idea of actorness. What is an actor? And who is an actor in international and EU law external relations? The EU is a very interesting thing to study if you don't know much about these things, partially because it's always changing, but partially because it's also trying to be very aggressively, in a very positive way, engage with international law and show how it changes, how it needs to change, and international law needs to be more receptive, to new types of organizations, non-state entities. And I suppose maybe it's useful to say, there's no key definition in any trade agreement of what is data. There's so many, if you look at all there's massive studies done by really great people, such as I love Mira Burry's work and so on. There's no global privacy or cybersecurity treaty. Some interesting things happening still, but the EU has generally had first mover advantage. And in a trade agreement, data has come up for cybersecurity, IP, transparency, frictionless movement of tech workers, and so on. But it's hard to really say that digital trade law and so on is engaging with all of these things, and vice versa. That's kind of where I'm motivated in all this. And I felt also that the GDPR is a bit obsessively focused upon by people, that there's lots of very interesting other areas of data issues that come to pass, but you maybe you don't agree with that. And I just wanted to do a project that was cross-cutting on the idea of data to data transfers and governance and cyber regulation, law enforcement, and the Internet of Things. I won't talk about law enforcement. Pretty much everything else I think is of interest. But yeah, that's so far. So what did I want to do? You're still alive? You're still with me? Yeah. Okay, good. Put step in the front for a reason. Yeah. So I wanted to call the book EU Soteric institutionalization. I thought this was very clever and funny, and I was really, you know, delighted with myself as I was sending this off to the publisher, and they said, no one is going to understand this or buy this. You've got to be kidding. And North Americans and native English speakers will think this is mad. Foreigners will just, no one's going to buy this, you know. I said, are you kidding? So I had to sneak it into the book, obviously, in other ways. So I passively, aggressively put it into different chapters in other ways. But I really believe this was, it defines of what I wanted to do, and I believe it's a descriptive project. It's not a very, you know, I don't think it's a massive normative intervention in the field, but I think it's fair to say that institution building is really the foundation of the EU's policy. That's how it became what it is, and the EU is really globally unique in its commitment, internally, externally, to institutionalization practices. And I think I was very motivated by a lot of literature from the 1990s, as CFSP stuff, but in general, the EU has a longer term vision of society through institutions, and it, you know, it very much rejects anything else. You could say it's liberal non-realist, but it really does have a consistent history of promoting and nudging multilateral innovations. And I did another book project on this, but I think it's very important to say that the EU generates convergence with international, not always in ways that people like, but it is very much a convergence actor. It tries to be good. It's in the EU treaties, in its DNA to be good, to promote international, promote good stuff. So I suppose I wanted to argue that digital infrastructures are very important to be studied, and whether you like them or not, the EU's data regimes are multiplous, and they vary as to their scale and complexity. We see this now, and I'm sure some of you are studying like the AI board and the AI Act and so on, but they mostly, as to institutional design, have a few real rivals. And when you decide to utilize more institutions and deeper oversight and more accountability and more legitimation, often people will say, well, that's very European. You're just being very EU-centric. And as I said, I've done a lot of transatlantic relations over the years, and particularly this is a very American critique of everything European. So I'm trying to zoom out if this is, if I'm zooming out effectively. But there's a brilliant guy called Schwartz, I think he's in Berkeley now, who's, you know, one of the most, it's a fantastic paper on this, that, you know, US and Asian models of data governance are just always defined by looser accountability and oversight. And I'll come back to this later on. The US is really trying to push for the global CBPR. And this is, I think it's a very profound question on, you know, not being EU-centric. What is EU-centric is our institutions. You know, like it or not, it is the EU's modus operandi. So I'm going in deep. I haven't got to got through it all. I was very motivated to write this book on institutionalization for another reason, that I feel a lot of EU law is very court-centric. I really feel that there's a whole generation of people that are, you know, the judicialization of EU law is kind of a core starting point on how to understand EU law. And this is a picture here. Again, sorry, apologies if you haven't eaten that many carrots as a child or you had a bad lockdown. This is a picture of the Court of Justice in Luxembourg in 2013. And I don't know if you, again, if your eyesight is good enough, but this, you know, some of the leading academics of EU law at this time were all invited to a birthday party. And the birthday party was the 50th anniversary of Van Rentenlus. And at the time I was working in the Netherlands, and everyone in my research group was invited to this birthday party, and hell hath no fury like a woman scorned, but in particular, no, that's a joke, but I was you know, very much, you know, struck by the fact that attending a birthday party, if you tell this to Americans, for example, would you go to a birthday party of Marbury and Madison? I think academics' draws would drop that, the idea that you would celebrate judicial activism. And so the core judgment of EU law, and you know, it's a cultural thing, right? That this is how you approach the subject, and you pay benevolence to the court in a particular tiny member state. But it is a philosophy. Now, you may not agree with me. You may say she's crazy, whatever. But I have very little case law in my book, and it's a deliberate choice that institutionalization is meant to be a different way of looking at things, because it is about frameworks, about you know, it's not about it's slightly more top down than bottom up, one might say. Anyway, there you go. That's the framing of the ideological challenges. Oh, sorry. So as I said, when I started this book project, probably more 2019, I was very much of the view that EU-US relations had reached a very poor point, a very weak point. Certainly, I had a Chair as Silvia said in transatlantic relations, and people said to me, "Are you really? How are you going to do that?" You know, in the Trump regime, there was a Trump administration. You know, it was a huge challenge post TTIP, as we all know. And, you know, who knows what's going to happen, but it certainly was a very low point for the aftermath of transatlantic relations, despite their, you know, the support for the European economy. EU-Japan relations, I think, are very interesting to study. I don't know if you're doing any case studies in EU-Japan, but it's a fascinating case study, partly because it's so boring. I mean, a lot of economists make fun of the EU-Japan agreement. What is it, wine for cars? They moved all the car manufacturing back to Japan. I missed that in the news. You know, don't buy a Japanese car without looking at the price about 10 times. And it's a very interesting agreement, and the data flow stuff is alongside it. The first post-GDPR data flow agreement, and it's a huge, rich, old area, just like Europe. You know, so it's a very interesting agreement, and they really, you know, culturally so opposed to institutionalizing about rights and oversight and so on. So very interesting studying the negotiations of that, and then EU-China relations, I think is really at this time when I was framing it, I understood at the end of writing this book project, contrary to my beliefs, there was in fact a very interesting study of much more convergence than one would have thought, a lot more comparative, you know, transposition of European ideas, a lot more openness, even to things like the GDPR and cybersecurity, but we can talk further on this, obviously a lot different. So that's kind of the overarching frame of all of this. So I thought today I would just briefly sketch through, am I okay for time? Just a few more minutes on the US side of things, and I'll leave it there. Sorry, that's to wake me up. Yeah. So over the years, there have been many forms of data transfer agreements. I don't know what this looks like if you can see the screen. It's probably an alphabet soup of letters, of years. And I don't know if any of you are interested in experimentalist governance or, you know, different types of engagement in transnational regimes, but it's a very good case study of lots of different types of data flow agreements. Whether you know about them, don't worry, but they change a lot. A lot of it is in the post 9/11 regimes, and they advance further. But in general, there's been tons of agreements on the left, and there's been tons of governance on the right, mostly quite problematic, not perfect, very criticized, but largely involving lots of actors and lots of reviews and lots of thinking aloud with each other on how to improve things, whether you accept it or not. And the most recent of all of this is the Data Privacy Framework Agreement of March 2022. And I got a terrible shock having handed in the manuscript to the publisher to suddenly see the headlines of the news. I got extremely upset. It's like writing your PhD on something, and then the entire basis for it just suddenly slides out the door, and you know. So anyway, I'll digress now. I've recovered after lots of therapy and talking to people, but so what happened? Well, you know, for someone who's trying to proclaim that the EU has lots of different, you know, institutionalization is an important frame. I haven't mentioned the Schrems case, which Schrems case is Max Schrems. I don't know if you know who this is, but I'm sure many of you do. But you know, there's been a lot of very important developments taking place, but largely as a result of an Austrian law student who got very you know, who did a huge amount of work to really upset the status quo. And in 2022, a new data regime was set up. And the reason it's so radical is that it sets up a redress system to resolve complaints about access of data. And it includes a Supreme Court, or a transatlantic court, a transatlantic data review court. So I don't know what you make of this, but there's no Japan court, there's no China court, there's no Korea court, there's no, you know, there's an adequacy decision with the UK, there's no British court. So it's a remarkable, weird institutional anomaly on any level. And again, I don't approach this as a data protection lawyer. I'm not, you know, that isn't my background, but I'm sure there's lots of very interesting things that one can say about it. But why is it a really remarkable thing? Well, there's an unprecedented commitment of the US in the first draft of all of this to strengthen civil liberties, to have a redress mechanism, and to have oversight. And you know, the hallmarks here are very European ideas as to how to deal with data here. There's also a court set up with a lot of individuals who are independent on the basis, again, of the criteria of the Court of Justice. And it was a very interesting point in time, because the EU was about to review all of its within 14 adequacy decisions and the 16 adequacy decisions. So why does this matter? Well, from an institutionalization perspective, I haven't kind of gone into my definitions of it, but I mean, it is quite remarkable to have the capacity to have a two-instance, a set of redress, to have oversight, and to ensure that there are binding remedial decisions. And you'll see that this was the pinnacle of various aspects of EU external relations. At the point in time, you see von der Leyen appearing with Joseph Biden. So it's optically a very, very significant form of evolution. And the devil, though, is in the detail. It gets the sting comes in the tail, because it's all legally very precarious from a US point of view, right? Whereas EU law adopts a very different perspective. So there's an executive order from President Biden on the detail of all of this about binding safeguards, and it introduces into US law very European words such as necessity and proportionality. And to this day, there's a lot of question marks about how possible this will be to implement it, and it establishes this very significant redress mechanism. Okay, so that's the really painful part of all this. Another very interesting thing happens, though. So I said the executive order is kind of on the US side of things. I'll talk about the EU instruments on the other side of things, but in the background to all of this, there's something called the EU-US Trade and Technology Council emerging. I'll talk about this too, Marta Concava. I'll try to, but it's a very unusual soft law mechanism that evolves in the background to all of this. And it becomes the principal place of data privacy and governance negotiations in recent times, similar to with India. India is as problematic as the US. Not anymore. India has just adopted very significant shifts in this, but it was perceived to be a very problematic localization actor. This is a picture from very recently in Belgium of the outcome of the EU-US Trade and Technology Council. I don't know if any of you have watched this online or been listening or following this in your own research, but it's almost like a family coming together for a family reunion, talking to how much they've loved meeting each other over the past 2 to 3 years. And it's a very strange, you really should see it if you're very interested in international relations, about the effects of institutional forums of engagements, even in soft law, and getting to know each other, I think is so in the background to all of these and that's a twice yearly executive to executive meeting, and civil servants have become very stressed in the EU about these meetings, because it's so much work to prepare your boss for the biggest summit of all time twice a year, right? And in the background to all of this, the EU develops an adequacy decision on foot of all the developments I just mentioned in July of 2023. And for many people, this is quite a big shock. It's a big, thick document, really interesting to read if you're interested in any of these areas. But it's you'll see that it's it links to the data privacy framework. So from an institutionalization perspective, this is real. This is quite interesting how this is evolving. And the problem about all of this is that the executive order of 2022 is the basis for the adequacy decision, that the EU can say, well, look, there's a legal basis for this in the US. And the European Data Protection Board issues a very stinging opinion on the adequacy decision and says this is quite difficult because it's largely unchanged. And the Justice Commissioner says, that we think Max Schrems is going to attack this. It's far from 100% certain that this will be legally watertight. And we see also very, very, what's his name? He's a brilliant Spanish Minister for Justice. I'm looking to Juan Fernando López Aguilar, the head of the Libe Committee, who spent a lot of time on this in the last while. And there's some really stark statements in its resolutions right the way through. The European Parliament has been very opposed to this, despite having an independent court, despite having oversight, despite having necessity, and so on, and saying that they urge the Commission not to adopt the adequacy decision, and adequacy itself being called into question. I think it's just a really, really, it's a stark statement, its conclusions at the end. And they also openly doubting it would survive the Court of Justice's text. Of course, Max Schrems in the background to all of this, has started his litigation on the adequacy decision and says, we've had harbours, umbrellas, shields and frameworks, but no substantial change in US surveillance law. And we're expecting this, I think it's later this year. So, despite the extraordinary advances in the institutionalization, as it were, it still is subject to, very important external questions. And I think, these are the kind of the standard critiques of data protection laws, political science, international relations, external relations law, but it's not enough as a legal basis, an executive order. It's not passed by the legislature. Is it, how directly enforceable is it? Is the bulk collection of data issue addressed? Is it okay to introduce proportionality? Is it still non-transparent, and so on? And I'm a big fan of Ken Propp. I don't know if any of you know who Ken Propp is. He's a brilliant former diplomat to the EU who's done fantastic work on. He's a justice and home affairs specialist, but he's written so many things about why he, and this is one piece in particular. This is just a short piece that from last year, on why under US law he would say that the EU shouldn't get an adequacy decision. So it's a very searching critique from an American perspective, much more so than I think the standard. And it's not just from constitutional law. I mean, it's somebody who he's worked a long time in the EU, and I think the data privacy framework remains a bit of a conundrum as to what are the limits of institutionalization. And if you don't find this interesting, I suppose just again thinking this, what is a transatlantic court? Why is one country so important it deserves its own? And I mean, again, coming from Brexit Britain, all I've heard about, I'm sure, Filippo, for many years, the Court of Justice is too powerful. It's impinging on the sovereignty of others, and so on. These are very normal debates. I'm sure in Italy you're hearing this all the time too, to a degree, and or any country that you're from, that it's not a new question. So what is an adequacy decision, and is it something we really, how legally concerned must we be about it? I think begs the question. And so Max Schrems is not the first person to challenge the DPF. In fact, there was a French MEP, Latombe, initially challenged it and was unsuccessful on slight administrative grounds. But you'll see that this is the current framework on which the none of your business, NOYB, that's the not-for-profit that Max Schrems runs in Brussels, and I think several people at the UI are involved in that as well, researchers. But I think it's a good question on how do we understand institutionalization as a solution to data? If what is how robust, how strong must judicialization be? And maybe just I'm close to finishing. Is that okay? Yeah. One of the most pathetic things that you can read in EU law, I think, I'll be so harsh in my critique and my language if it's not inappropriate. I hope you don't mind my criticism. That the European Commission review document from January this year of the 16 adequacy decisions is a remarkable light touch review of the executive dominance of adequacy. The European Parliament will tell you that they feel really excluded and left out of the lawmaking procedures. It's a very remarkable feat of the legislative process about how to amend these, and it's a very weird collection of countries that have adequacy decisions: Andorra, Argentina, Canada, Faroe Islands, Guernsey, Israel, Japan, Jersey, Korea, Switzerland, and so on. I mean, I was teaching a course a few months ago and asking students to kind of come up with lists on why you understand this collection of countries is the collection of countries that has the best data standards in the world, and how, for example, countries such as Israel had very, interesting COVID laws, are very interesting in the sense of very, technology savvy countries, and it's very hard to see the Commission engaging any searching review. So I think that part of the process has seen the court inject itself in and added an extra dimension to its judicialization of all of this. And I've done a lot of work with Fabien Turpin and Sciences Po in Grenoble and his colleagues on this, this judicialization matters, right? So I tried to be very snobbish at the start of my talk and say it doesn't, but I mean, that is the reality, certainly, of how EU law works. So I'll very briefly just to summarize, to say that, in general, strong institutionalization can be said to promote strong judicialization. If you like that, maybe you don't believe that. Maybe, you know, that's not a framework for everyone. But there clearly are very, you know, significant limits to institutionalization. There's no shortage of people in the EU, of 500 million people, think tanks, modern, you know, society, lots of people who are willing to challenge EU law, the elite actors, big tech and so on. We're not short of people. But empirically, the DPF is now seen to be so vulnerable that lots of businesses are simply not using it, I think is the data on this, which is interesting. And I come back to the starting point of the framing of my book that, you know, is the EU-US relationship its strongest or weakest link? I still think is a lot more open to challenge. I hope I haven't been too long. Thank you very much.
Thank you very much, Elaine, for your insightful and powerful presentation. Okay. Yeah, it's open. Yes. Now I will give the floor to the first discussant, Dr. Fontanelli. Yes, please.
Thank you. I'm going to speak to this presentation in part. So sorry if I'm looking that way. It's just because of the setup here. Can you hear me all right? I'm going to speak for 15 minutes, maybe less. Yeah, can you hear me? Well, can people in the for the recording hear me? Yes. Okay. So first of all, very many thanks to Giuseppe and Giacomo for the invitation, Silvia, and of course, Elaine. Great book. Yeah, the color thing was a bit puzzling and disorienting, but I think it's still the same book, right? So it's a great book. If you haven't read it, read it, but set aside a bit of time. It's not one of those books where you think it could have been an article. It could have been several articles. It's very dense. And I think it goes to one of the points I'm trying to make. So I want to make 2 points, and these are more for reflection and are coming from a place of relative ignorance. So I represent the audience here. So the book is very dense. It's very dense with information. And because you describe the process of institutionalization that consists of processes, policies, and actors, and engagements and actions, and all of these things that are not necessarily laws and court decisions. And that requires an enormous amount of surveying the territory and mapping the land. And that is not something that one possibly knows by heart. It requires a lot of research. The research is there, so it's terribly informative. So I'm trying to make 2 points, and one is related to this idea of having to deal with an incredibly dense and fairly subterranean range of materials. One is the institutionalization idea and notion, and whether it is, as it is presented in the book for the most part, a very positive one. And the other is rather a suggestion that I've had, and I want to put to you and everybody, and it came from the discussion of data localization, which is an aspect of how the EU deals with its trade preferences and its trade policies in data, and the idea that it requires data to be held and processed locally. And that gave to me the idea of thinking, is that similar to some of the process of localization that are going on elsewhere in the field of external trade policies? Right, so I'm going to deal with these 2 points in turn, and then maybe there's going to be an occasion for you to I don't know, react, and for everybody to do whatever they want to do. So institutionalization is, and correct me if I'm wrong, presented as a nice thing, slightly understudied and underrated in a sense, and I think this is a quote somewhere, it increases effectiveness, and it's somewhere it says, the book says, that it increases legitimacy and transparency. So it's presented as a nice thing. And it is the increase in processes and interactions between entities and cooperation with external stakeholders and I mean, everything you can think of. It's this a body of practices and processes that is presented largely as a positive thing to make things happen. And I'm trying to see whether there is some dark side to the idea of institutionalization. And I'm trying to, first of all, and I'm trying to isolate things that might be less angelic. I'm sure on the average, this is good. But institutionalization, I'm wondering, isn't that also how we call bureaucratization? So the idea that there's going to be more and more actors involved with every decision, with every policy, and more materials to know that are increasingly known only to the insiders. And a good example is the TTC. TTC, super current, probably nobody even knew it existed. If you are in the know and you really want to know what they're doing, it's still not easy to understand what they're doing. You know, meeting by meeting, what they have achieved, what they'll be talking. You know, you have to have the occasional insider somewhere in specialized press. They have leaks on what they're going to talk about. That's the level of, you know, specialization that certain dedicated and engineered bodies are now dealing with, you know, the future of, I don't know, data protection. And it's very difficult to follow. It's not something that you can open the treaties of the EU and say, well, there's going to be this transparent thing going on and I can follow. It's both very specialized and promising and also a bit out of reach for the purpose of accountability on even just transparency, I suppose. It's a bit impenetrable. And impenetrable, a very advanced level of institutionalization is also why instead of the Brussels effect working only because of the size of the EU market and the importance of what the EU does, is also because sometimes from the outside, it's just so impossible to engage with whatever it's already there and the various actors that it's easier just to adapt. If you can adapt and follow, I don't know, all the GDPR requirements, then it's probably easier than trying to negotiate around those. But that might become just, you know, it's like when they tell you, you don't negotiate with the Russians because they can always stand up and leave. And that makes them, paradoxically, very good negotiators because you break the boat. And so there's that level. And a good, I think, comparison is on unilateral matters that condition trade to human rights or sustainable development or labor. Or there are countries around the world that say, I'm thinking EU Mercosur negotiations, and Brazil is saying, listen, you're asking me all these things that are conditional on trade. I'm not sure I want to do an FTA with you anymore. And so it's that level of institutionalization of several things on corporate social responsibility and human rights and labor that sometimes the partners are thinking, this is a bit much. You're a bit intense. I'm not sure I want to do it any longer. And also, it's interesting to see with all these new actors and legal materials that are not necessarily primary law or secondary law or anything in between. There's a proliferation of policy documents, and twice a year we have these enormous documents, and then we have a document that is a commission plan on economic national security, and you read it and it tells you what's going to happen in the future, but it's not law, so it's difficult to challenge it. You're not entirely sure whether it binds the EU, whether the third parties, the third countries are going to read that and arrange accordingly. So on the one hand, there's a lot of flexibility in the shapes and the sources, and it moves sort of in the gray areas of accountability, because these are not processes that are clearly regulated discipline in the treaties. So I'm not entirely sure whether there's more accountability or less accountability. It's difficult to tell, because these things which move away a little from legalization and judicialization and reviewability are also fairly political. It's difficult to see exactly how this could be challenged, who is responsible for those. And And so do we have the pulse of the dark side of this? Is it going too far? Is that becoming a bureaucratic moloch that just works until third parties feel like they have to deal with it, or is it a bit much? Okay, I'm not entirely sure how much time I have left. So let's say 5 minutes on the second suggestion. 5 minutes, all right, more or less. On the second suggestion, which is a delocalization. So, sorry, localization, which is a trend, just to give you an idea, not an expert, but to the extent that the EU and other parties, of course, but the EU wants to regulate digital trade, or whatever that means, in trade agreements, it's increasingly, or as a trend, trying to impose data localization obligations. Is that fairly correct? Yeah. Which means the EU is trying to make it a condition to trade that whoever collects and processes data does it wherever the data is collected, so locally. There's not a lot of uncontrolled flows. And that sounds like it's presumably premised on the protection of the data subject. So it's one of those things where the European Union comes strong first with a principled view, and then the principled view also becomes the condition to do business with the rest of the world. And we're sorry that that entails costs and it's burdensome, and maybe you didn't want that, you don't have the same culture, but that's how we do things here. And it's sort of imposed on the rest of the world. And sometimes that is happening in various other fields. One we've already touched upon, the idea that if you want to do trade with the European Union, there's a lot of sustainability, and it cannot be deforestation, it cannot be excessive pollution. So there's a lot of conditions based on principles that happen also to be costs on doing trade with the rest of the world. So it might be part of a general trend. And I think you also mentioned everything is geopolitics now. So it's not unconscionable to see that happening more or less everywhere. The more eerie comparison I had in mind is the process that the European Union, like other countries, by all means, has been doing for the last 2 years of trying to impose pretty much or subsidize heavily the processing in the European Union of rare materials, raw materials, rare earths that are very necessary for future production of certain technological equipments. And so it's very important not to be dependent only on buying from China at any given time. So trying to have an industry of that is very important, seen as a priority. And it sounds like it's a selfish idea, but it's premised on the security and economic security of the European Union. And so there's this process where an enormous amount of resources and political will is going to the idea that there's going to be a localization of the processing of raw materials. And it seems to me that there's something in common between the idea of localization of data protection, processing, and the localization, the sort of force or promoted or paid for localization of raw materials that goes to the I don't want to say selfish, but fairly opportunistic view of the European Union as somebody who can simply have ambiguous goals. These goals are both principled because they go back to either security or human rights or consumers protection, but also convenient when it comes to trading with the rest of the world, when you impose, you basically offload some of the costs of doing business with you and others. And so the idea of technological sovereignty, that is one that the EU is trying to pursue, is also similar to the idea of having sovereignty on certain key materials that might be crucial to be in the right place industrially 5 to 10 years. So I'll keep it here, but if you want to have a sense of just exactly what the EU keeps doing constantly, and if you follow Steve Pierce on Twitter, everybody does, I think, there's a couple of pieces of news. One is, and both relate to how the EU sees the rest of the world in the digital field. One is the determination that a big adult videos provider, X videos, is qualified as a large provider, so that there are immense obligations under EU law. Like there has to be a search engine for advertisement with a lot of information, so a lot of costs on a business. The other is that Booking, Booking.com is qualified as a, I can't remember what it's qualified at, but yeah, but it's not under the same regulation. There's a couple of 2022 regulations that I don't know much about, but again, qualifying in a certain way, there's a bunch of obligations and duties that come with it. So the EU is in that business, sort of. We have a bunch of digital regulations, and if you want to operate here, we tell you what you stand for. And sometimes it's very, very sensible. The Booking, for instance, you're so big that we need to make sure that you give access to other competitors on your platform. But the X videos is a bit weird. It's like you need to have a search engine for the advertisements that you run on the website for 1 year. And it's a bit inscrutable. And again, it's the price of doing business with the EU. There's a lot of principle stuff. There's a lot of overcooked stuff, seems to me. And some of that is fairly unknowable. And so the institutionalization is doing a lot of work for us, citizens of the European Union. And but it's probably straining the patience of everybody that does business with the EU. And so I'll put that to Elaine and shut myself up. Thank you very much.
Thank you very much for giving us your view and for the points raised. Now it's time for our second discussant, Mr. Kunhao YANG. You have the floor.
Yeah, thank you. Now you can imagine after the beautiful discussion kick off by Filippo is how hard it is to follow up. But I try to add more oil to the fire to open up the discussion. Yeah. So my name is Kunhao YANG. I'm a PhD researcher from the UI, working on the EU external relations, especially with China in the climate and environmental related areas. So my comments will more from the global reach of EU law. Yeah, I'm not an expert in the digital, sorry for that. Yeah, so the first time when we met in Bologna, when we have chance to engage on this topic, and what the first thing came to my mind is how could I miss this monograph in my literature review when I was composing? Yeah, so I'm using a very descriptive way to unpack this contribution to the scholarship. I think so. From what I learned from it, it sets up the theoretical scene of framework of institutionalism in how to look into the EU as a global digital actors in the digital economic. So I would say from a vertical and horizontal way, how I understand it. So the first 3 chapters look into the data regulation, the digital trade, and cybersecurity from a vertical way to look into when the EU comes to with different global actors, what did the EU do? And what kind of institutionalized system or structure has been established? And then it comes to the 3 different actors, the US, Japan, and China, and to look into detail or the case study, what is the process of what's the dynamics behind this? So this is my understanding of the structure. And so here, the most important theoretical framework of the institutionalism is, as I quote, this is a process by which an organization becomes increasingly subject to rules, procedures, and stable practice. So this is a way how the author look into the EU provide the global solutions to many transnational problems. And why does it matter? Or why should we look at the EU roles as a global digital actors? I think 2 things we can learn from this analysis. First is due to a lack of the international standards. You see what happens in WTO, and also a lack of standards internationally on digital trade. So the EU is promoting to setting the rules in this area to fill the gap in a unilateral way to projecting the rule setting. And the second one is more and more digital or data challenges is a transnational challenge of problems, which involves more foreign related factors, requires the more unilateral or bilateral methods. So based on this theoretical basis of framework, I have a question in my mind is, so when we deal with the theoretical or literature reviews, it's like, what is the contributions of this theory to the scholarship? So I think, in this, so the lens of institutionalism, what's the, how does it contribute to the global reach of EU law or the extraterritorial effects of EU law? We see there's a bunch of theories, Brussels effect, which tell us the mechanism how the third countries companies voluntarily adopts the internal market rules and then upgrade it in a de jure ways to the third country standards. And there was also theory like normative power, market power, who centers on the role of EU, why the EU can extend its rules. And also, Professor Cremona, talk about the linkages, the technique that the EU, how inserts the values like sustainability, like human rights, environmental protection into the FTAs. And Professor Joanne Scott mentioned the territorial extensions is a kind of technique. So this kind of literature, so based on this, what is the contribution of this institutionalism theory? I think it provides a lens of how the process, a dynamic from internally and externally, how does the process of EU establish the extension of EU law or the global reach of EU law in the digital areas? So what we can draw here is that there is no single answers to the global reach of EU law. We see when it comes to different domains like digital trade and the cybersecurity, there are different answers. It doesn't mean that EU is a global digital actor, so everything works. And when it comes to different jurisdiction or countries, when it comes to US, what you term the loose institutionalism, and the Japan's the best practice, and the China is the reverse Brussels effect. So we see the EU global digital actor does not work in one way. So that is the dynamics I think it's a very important contributions to us is Brussels effects or other mechanism here is only one way to look into the global reach of EU law. And when it comes to different domains, different external players, there may be different answers. So based on this takeaway, I have some questions jump to my mind, which may be useful for the follow-up discussion. The first one is the concept of institutionalism, right? So you also mentioned in your PPT slides about the critic or the comments on the EU-centric or the European-centric. So I would wonder, or would you like to say a few more words on, so how would you look in this term? You use these terms especially in your introduction chapter. Do you think it is a EU-based, or we don't say EU-centric, but is this a EU-based term? So do you unpack this theory standing in the EU to look at the world, right? So if it is true, then a follow-up is, what is China and the US learning from the institutionalism? Are they doing what the EU has been doing to institutionalize the digital or the other areas, like learning from the EU? But maybe it will lead to different outcomes due to the divergence in values. So what do you think? If you are using this term as a very neutralized and general, is a neutral word or term of theory framework, then it may apply to different jurisdictions and different circumstances. So I wonder so would you say a few more words on this? And another example is So you also mentioned in the chapter about China, that's a Belt and Road Initiative. Yeah, a few weeks ago, we had an event in UI, Joseph, also present on the soft law approach. So, but under this soft law approach, it doesn't mean that there is no, based on the definition of institutionalism, rules, procedures, or legal practice. There are, right? It is soft law agreements between China and Italy, but under these soft law agreements, there are other legal sources like companies to companies, project-based contract, other agreements, which is in a micro lens that we can find. So do you think this is also a kind of institutionalism, right? So what's the dynamics here to compare? The second question is, so the global reach of EU law, as I mentioned, is not the first day we're talking about the, in your previous monograph, you also draw our attention to non-economic areas, how the global reach of EU law works. So I'm wondering, do you see an involvement in the practice of the extraterritorial extension of EU law? So 20 years ago, when Ramona mentioned the linkage, is the EU, the spillover is about the spillover effect or the external dimension of the EU law. While we see nowadays the EU is more actively pursuing the external or geopolitical objectives by using the EU law. So it's from a spillover effect to and more actively pursuing, this is an involvement I can see this process. So would you like to say so based on your previous research on the non-economic areas and now to the digital areas, do you see also a involvement of the extension of EU law? And the remaining question is about the self-limitation of the global reach of EU law. So based on the EU-US cases, you can see the Court of Justice of the European Union functions in reviewing the agreements between both sides. And there are also other cases, for example, the AI Act. The AI Act is adopting another approach to, not like the GDPR, to limit the extension of its material scope. So do you see in this area the EU law, the EU institutionalism itself is limited its extensions in some way? Right? The final questions here, the final, is about the future. So about the future of the role of EU digital actors. So we see China is more actively engaging in the CPTPP and the RECP. So different regional trade agreement emerges, global legal orders. And there are also others from the other side, the EU, US, TTC is also functioning to extending the areas. So do you see the future in these digital areas is more regionalized? The standards will be regionalized, or do you see the EU Europeanization still can achieve its regional aims finally? So that's all my stage. Thank you so much.
Thank you very much. Now, for the sake of time, we have more or less 20 minutes left. So if you're okay with that, Elaine, we can open the floor to collect some questions, and then I'll give you the floor to give a comprehensive intervention. Okay, so are there any questions from the public? Please come here because we have to get the question registered. Thank you.
Hi, thank you very much for the nice presentation. I just have a question concerning, you mentioned that the adequacy decisions and the institutionalization of the whole process. But I want to say that if we look back at the Data Protection Directive, you also had this requirement of adequacy decisions. And if we analyze this process, you mentioned the 16 adequacy decisions which were issued basically without too much analysis. this was the case under the Data Protection Directive, and it was like an analysis of the data protection legislation of those countries, and the Commission concluded that they respect data protection. Later on, you had abuses of data privacy and of data rules in the US, in China, and in other countries, which kind of triggered this reaction from the EU. First of all, you had the Court of Justice, which canceled the Safe Harbor framework, and then you had the Schrems cases at the European Court of Justice. And I feel like the EU here is presented as something that tries to regulate everything that moves, but in reality, I would say that the EU says we have a certain set of rights for our citizens, and we want to ensure that those rights are not violated in the US when you have data transfers. Hence, institutionalization, because under the, I think the Privacy Shield, you had the ombudsperson, and the Court of Justice said that's not good enough to ensure compliance with human rights for data protection transfers. And now you said that they have a court which more or less ensures that it's a judicial standard of review over the data processing which is happening there. And I want to know your opinion on this take, if the EU is now out of this phase of reacting to something, and it's kind of going over the board and trying to prevent, let's say, in the AI sphere, you know, we can also have these abuses of data and of human rights. And thank you.
Thank you for your question, Gabriel. Do we have any more questions? Please.
I write some very interesting questions. I really love your topic. You discussed like relevant to the data transfer. Okay, data transfer and institutionalization at the EU level. So the first question is, like, we created a general principles at the EU level, but it still needs to leave the space to the, you know, the member states to adapt, you know, to their own national environment and cases. So that's the first question. How can you balance the space between the general principles and the national cases? So follow this one. And you mentioned that the EU and China selected another way, the loose regulation framework, which is different from the EU. So I'm thinking maybe the regulation framework is just an outcome. So maybe it responds the, you know, the balance of values like the efficiency and privacy. So I think it's very hard task to, you know, balance, you know, the values preferences. So it depends on the culture and depends on the policy system. There are too many complex questions in this part. And the third question is that you talk the EU and the US data privacy framework. I feel like that you want to create a global or cross-national standards to, you know, to improve the data transfer or make it a single data market like this. But the question is that if you want to create a global standard for all countries or the almost countries, so I would like to ask, you think this global standard must be physical, fundamental, or it must be keep a high protection level, like the high protection privacy level? So if it keeps a high protection level, it means that will it hurt the small, medium companies, or will it hurt the developing countries? Because, you know, it's not just legal issues, it's also relevant to the high technologies. So maybe the small and medium companies or the developing countries, they can't have a very high technologies, they can't reach the high protection levels. So maybe it's a heart of the small and developing countries. So that's all my questions. I really love it. So thank you so much for your presentation.
Thank you very much. I don't want you to overload with questions, but if there's any more question, the public, please, thank you.
Well, thanks indeed for this great event. I'm very happy. I think that's, I want to thank you all. I mean, also on behalf of Giacomo, I mean, we immediately, I mean, perceive this book launch because it's a very important, I mean, Stals event. And then they're going to say a couple of things about why with Giacomo, they decided to devote a Stals seminar to this book. It's a fantastic work. It's a gem. It is very interesting to constitutional and comparative lawyers. For instance, because in my view, it represents the perfect case study, which shows why EU law can contribute to the functions normally performed by constitutionalism. I mean, indeed, this that agenda, this digital agenda shows how EU law can help in actually capturing phenomena that cannot be governed by domestic law only. So in this sense, EU law is really crucial to govern and to tame, I mean, new forms of power. So in this sense, it is a fantastic book, which in my view, I mean, offers a lot of insights if you're interested in this phenomena. It's also very interesting to comparative law scholars because studying the global reach of EU law also, I mean, paves the way for a study of dynamics of circulation of legal transplants in a way. So, I mean, this is not, of course, I mean, this goes beyond the scope of your book, but this really, I mean, creates a research agenda also for the comparative law scholars. So for all these reasons, we immediately think that was a very good idea. So thanks indeed for making this possible. And then I have a very short question. I mean, it touches upon what Kunhao already said. I mean, when I studied some years ago with the Professor Elaine Wu, the Belt and Road Initiative from a legal dimension. Well, at that time, there was a debate about how the Belt and Road Initiative was a part of a global strategy launched by China. And at that time, I remember many scholars who argued that China was using the Belt and Road Initiative to act as a rule shaker, in a way, to question a certain idea of global governance. Now I see, and I think that your book is again very helpful, a trend actually followed by other big actors of global governance who are also relying on soft law. So my question for you is, are we witnessing actually a scenario in which China has become a trendsetter? So instead of acting as a rule shaker, is China acting as a trendsetter? What do you think about that? Thanks so much again.
Thank you very much, Giuseppe. So now I give the floor to Elaine. Thank you.
Well, thank you so much. That's not an easy task for me. Thank you so much, everyone, for all the really great questions, and to all the people who had to read everything, to Filippo and to Kunhao for all the fantastic, very searching questions as well. So maybe I'll go backwards, and apologies if I don't hit them all. That's a really interesting question, Giuseppe, about the BRI's role in all of this. I think personally that China has become a lot more integration, like into internet, and I don't know what people think about who work on this, into international, or trying to, the ORCEP, or trying to really step up its in legal engagement with the international agenda and use of it. So moving well away from the BRI. By contrast, the EU and the US are saying, trade law is old-fashioned and boring, and it's all about soft law, digital partnerships, and I'll talk about that a bit more tomorrow. So I wouldn't agree, about the framing, but I think you're right that the soft law has not gone out of fashion, and maybe I'll come back to Filippo's point, I think, on this as well, and several other people, but I think you're right that the circulation of legal transplants is very much kind of a core part of understanding a lot of this. And I suppose but I'm a little bit more boring and process oriented about the, but I think it's a good normative framing of it. But I think there's someone, maybe Filippo's colleague, Chad Dammer, has done a lot of work on this, on the, also Alistair Young, and if people know him in Georgia Tech, on adoption of EU standards. But yeah, thanks, great questions. Really interesting questions from this lady here. I think you some question about the space between general principles and member state principles, and then that's more about the data protection. That's a very interesting question about the one-stop shop, and I think there's lots of great data protection lawyers that are working on. Is someone's colleague Gregorio? I think, doesn't he? Or a brilliant Italian scholar. What's her name? In Essex. Yeah, in Essex. There's a girl in Essex. What's Julia Gentile? They have a really good piece on this, on, you know, getting rid of the one-stop shop. So I think you're really right on this. I think you posed some very interesting points then about, you know, high levels of protection for developing countries, small companies. I mean, it's the same for like the carbon border adjustment mechanism. It doesn't, you know, a lot of the same debates. But I take the point. I think it's a really, really interesting question you raise. I think I can't remember who. Oh yeah, sorry. You're absolutely right about the. Yeah, is the EU out of the reactive phase? I was interested in your phrasing of this, because like that's an important point, because the AI stuff is all about from product regulation. But again, I don't approach all this as a data protection specialist. There's much more, but I think that's an interesting question, that the EU couldn't come up with anything more interesting than a product safety regime. But at the same time, the US is following its AI board, but in a non-binding way, right? So that's so I think that's how I would engage with that question, and say that, you know, that it's an interesting point about at what point does the EU become less reactive, when it's, you know, what does it draw from? Well, the frameworks that it knows. But I mean, maybe I'm being unkind to the EU, but I think it's a really interesting question. Generally, I can't remember. I think this is Kunhao. Really interesting questions there on maybe the Belt and Road Initiative, the soft law question. That goes also to Giuseppe's point about. For me, the Bureau or soft law, or the TTC, maybe Filippo's point as well on this, that's not Article 218 TFU. That's not EU law, right? That's an important point, that it isn't an institutionalization example. It can't be, because it's not binding, right? So I take the view of institutionalization involving binding legal processes. So yeah, very, very. But just coming back to Kunhao, I mean, you know, people like the Joanne Scotts and the New Bradfords, they're the people who've done other very interesting normative framing. I'm a bit more unglamorous and boring about the unfun questions on how it happens. And I suppose that's why I feel it's important to write books like this, that you know, the end point is really complicated. Political scientists, for example, take huge issue with a New Bradford's work. Even digital empires, you know, Alistair Young has written so much on this. So it's hard to say the EU is so great and so super, right? I knew Bradford wrote the book because their classes weren't popular enough in New York. You know, law students said, I'd rather take Soviet law than learn about the EU. I feel that in Brexit Britain too. I'm being told the Europe is not interesting enough for me. There's, you know, I have students from all over the world. So I know. That is, you know, this question of how relevant is it, and I think the territorial extension stuff as well. I liked your point about the geopolitics of EU law more than that, and I know, you know, Cremona's work is so important. But again, I don't know if any of you know Sabine Wayard, you know, one of the EU's leading trade negotiators, and she's recently given a talk on much more humble, I think, and modest, and that, you know, we can't go out to the developing countries and say to them EU law is great and take our standards. There's a real difference and nuance in her take on all of this, and I like to see that those are interesting developments. And maybe that takes me into another point about a little bit closer to Filippo's point as well, about you know, digital diplomacy is really relevant nowadays on how the EU, I think your last point you were mentioning about DSA and the DMA, all the designations and so on, but the EU is actually has a whole new office in San Francisco, the digital diplomacy office, right? So one of the first things, Joe Biden came to office and said the EU's regulations are anti-American. There's only one Chinese company on the top of the list, right? So for all the anti-Chinese bias and so on. So I think understanding methods really matters. And I suppose maybe I'll try and link Kunhao and Filippo. I haven't had too much coffee, enough coffee today, maybe for the great questions. But yeah, I'm really interested in processes, and I think that institutionalization is generally a very positive thing for the EU. But you're right, there's a lot of negativity when you say someone's institutionalized. You know, they've been in a university for 20 years. Your colleague is institutionalized, or someone who's it's not necessarily a nice thing to say about somebody, but there is a stabilization there that I think I'm trying to hit out at. So I really liked your characterization of, you know, being too positive. Or bureaucratization matters to the EU, though. That's how it deals with life. And the TTC for me is not institutionalization. You know, bindingness is a very important thing. But look how open EU law is, like that the US can respond to the GDPR, Venezuela and Russia can challenge, you know, clearly there's an openness to EU processes of how its institutions work. And I suppose, yeah, very interesting comments there on the EU as a soft data. I think in my book I've written about this as a soft data localization act. I think you know, Chandler has written so much in this, and you know, that's a very court-centric idea, but that the EU through its court has engendered this in its digital trade chapters is a lot more open, and I think that matters, that data is special, and that there's a hybridity in regulation that is also playing out in external relations. So it has all these beautiful local model clauses and localization that in practice third countries say, yeah, we don't, you know, we don't accept all of this. And I think as you said, Russia and so on, it's important to remember how the world works and how to, you know, trade negotiations are, trade is very much out of fashion. And maybe that comes back to Kunhao's point about, and I'll stop on this because I'm talking for far too long, sorry, that, you know, that we live in a world where trade is viewed to be unpopular. Trade agreements are really out of fashion, and law is you know, it's all soft law partnerships. Well, at least I think so. Yeah, some great questions. I don't necessarily have answers to them because the geopolitics of everything has changed a lot. But you have some, yeah, I think there's some important questions about the transnational challenges there. How, you know, institutionalization, I think, is a very modest descriptive contribution to where that sits. But anyway, to be continued, as I said, it was to be continued from January 2022. So, you know, anyway, thank you so much for everything.
Giuseppe, would you like to add something else, or shall I close the seminar? Okay, so this has been a very interesting seminar. Thank you very much to Professor Elaine Fahey for sharing her fantastic research. Thank you to the speakers, to Giuseppe and Giacomo for organizing the seminar, giving me the chance of sharing it, and to all the participants. Thank you and see you soon.